There we were. For a moment, I was reminded of an old Meatloaf song of 2 out of 3 ain't bad. So, but I'm glad to see Mr. Caldevillo got brought in and we have everybody. My understanding, and please correct me if I'm wrong, Mr. Lugo and Mr. Baraki, is that you will be dividing your time?
Yes, Your Honor. Good morning. David Baruch on behalf of Camilla Reyes. And in speaking with Mr. Lugo, we've agreed to split the time and that I will be taking the first 10 minutes.
Okay, and does Mr. Lugo and have you agreed to reserve any time for rebuttal? I assume we're going in the standard operating manner.
Your Honor, I'd like to reserve 2 of my 10 minutes for rebuttal.
Ah, okay.
I would like the same, 2 out of my 10 minutes reserved for rebuttal.
All right, so then we will do the first argument for 8 minutes, segue to Mr. Lugo for 8 minutes, and then we have Mr. Caldevillo for the full 20, then followed by rebuttal for 2 and 2. Do I have it correct?
Yes, Your Honor.
As you can tell, I was not a math major, so I have to confirm everything. All right. See, Mr. Baruch is back. See, Mr. Baruch, you don't have the prompt that we have. Our marshal is good enough to send us an email just before we start in most cases. Do you have your robe on? So
I'm a long-time listener, first-time caller.
Been much for all of us to have to learn how to do this. So we have everyone now online. I think I have the time worked out. So Mr. Baruch, I believe you said you would be going first. You may proceed, counsel.
Good morning, Your Honor. May it please the court, David Baruch on behalf of Camilla Reyes. This appeal is from an award of attorney's fees pursuant to an offer of a judgment. The offer is unenforceable because it included a non-monetary condition that made acceptance impossible. To accept the offer, Mr. Reyes had to send a check for $125,000 in 20 days to counsel. Reyes, who had only...
Mr. Baruch, can you agree that the offer was at least facially sufficient by the statute and by looking at the rule?
Well, Your Honor, we have several arguments. Our principal one is the possibility of acceptance created by this non-monetary condition.
I understand your argument as far as the condition, and you're referring to the rule that talks about that particularity with with any relevant conditions. And so if you look at a relevant condition, payment is obviously a relevant condition, right? So can you not at least agree facially that the offer was sufficient just by looking at the statute and the rule?
Your Honor, I cannot. I can't agree. We do have other arguments regarding ambiguities and garbled language in the offer. But of course, our principal offer,
and so your impossibility argument is that based at the time that the offer was made to your client, because they could not tender payment and didn't have the sufficient cash or liquidity to tender payment within the 20-day period, that it was an impossibility. And you've likened that to the Dacedu case where there was a loss of consortium claim that was in a release, correct?
It is, yes, that's one of our arguments.
And I guess the issue that I have with that argument, and I understand your argument as far as impossibility, but that is an argument that a lot of defendants may very well have. And so then it opens up the door, at least for me, to some sort of prejudgment discovery as far as whether or not someone would have the ability to pay or not. And if the whole goal of the statute is to end litigation, we certainly don't want to do that prejudgment.
Correct.
And this is something that is best left for post-judgment, for when a court is to enforce the offer of judgment, is it not? Because these are all issues as far as whether someone has the sufficient enough assets that the court can do in enforcement of a judgment?
Your Honor, yeah, and our position on the evidentiary aspect of this is that it's not worth the price of the candle. And frankly, our argument sweeps broader, and that categorically non-monetary conditions of this sort should be disallowed, because what you're doing is you're introducing into the statute a wealth test. So an individual who is wealthy or who has adequate insurance coverage and a cooperative insurer.
But on the face of it, how do you know it's, I mean, a non-monetary, I mean, you're calling it a non-monetary condition. And then, so don't you need, as Judge Smith suggested, some sort of factual basis, since it's not facially a non-monetary, to discern that it's, in your estimation, non-monetary?
Well, it's non-monetary, Your Honor, in terms of there's a temporal requirement, and that's really the focus of the problem. It's not that the offer is $125,000. We can certainly address that, and if we can settle the case for a judgment of $125,000, that doesn't bring the ability to pay and the wealth of the defendant into it. It is the time component that is the non-monetary condition.
So unless it's open-ended, pay me when you get around to it, there's a non-monetary condition?
Yes, Your Honor. The time-limited payment demand is the non-monetary condition that makes acceptance impossible. And it's, in our view, categorically should be disallowed because it introduces a wealth test into the statute. It advantages wealthy people over poor litigants. And it is something that overthrows how the statute is supposed to work. Served on a defendant, an offer of judgment is supposed to force an early determination of the merits. And if the offer is accepted, a judgment is entered, the lawsuit ends, and resources are saved. The plaintiff can then collect on that judgment, subject to the statutory and constitutional protections afforded to debtors, and subject to perhaps the prior rights of non-party.
No offer can comply with the statute unless it's open-ended as with regard to when payment can be made?
Your Honor, yeah, absolutely. That's our position. That categorically, this introduces a direct obstacle to the acceptance of an offer of judgment, never intended by the statute. And if it's a time-limited payment demand, it throws the merits aside. It throws the assessment of the claims and defenses aside, and almost invariably is going to force a party to look to third parties for funding. So Mr. Reyes doesn't have $125,000 sitting in a bank account. He needs third-party sources, just as frankly anybody would, to be able to satisfy that
Is
payment.
that in our record anywhere that he has no money, has no assets? I saw there was a reference to an insurance policy for insuring certain cars, and he might have some land. But the last point, how do we know whether or not he has money in the bank?
Well, Your Honor, what we know and what was assumed down below, what we know is that he had a policy for $10,000,
Correct.
the bare minimum. And Security National appeared at the hearing. They had a lawyer there. And counsel's argument below, and what convinced the trial court, is that the ability to pay this time-limited demand, which shows the merits of the offer aside, was irrelevant. That was the argument repeated again and again and again below. And what plaintiff's counsel introduced as a secondary argument is that Mr. Reyes had an $85,000 house and he had 3 cars, all of them low end, none newer than 13 years old. And that gives the game away, because one of the prohibitions is that an offer of judgment is not enforceable if you are dependent upon a third party, if your independent control over acceptance is taken away. And so their argument below was first that it's irrelevant, and second, that Mr. Reyes should have conducted a fire sale of his house and assets within 20 days.
It also seems as though the operational impact of this offer of judgment is to change the law in Florida for post-judgment purposes. Your homestead, if it's the residence you mentioned, is exempt from execution. Here, if you don't liquidate and not claim it, the argument could be made, now you'll have a sanction of attorney fees.
Exactly, Your Honor. It is a court-ordered sanction that depends on susceptibility to which depends on the wealth of the defendant. And
Baroque, so if you're claiming impossibility, so whose burden of proof was it to prove that at the hearing then?
Your Honor, we're in new territory here. Okay, this is a novel issue.
Well,
I
not
understand.
necessarily. I mean, if
And
you're saying there's an impossibility, what was the court to hang their hat on as far as impossibility? Because,
Your Honor,
go ahead.
again, so what we understood below, what was assumed below, is that known that Mr. Reyes only had $10,000 of insurance coverage, which is itself a strong indication that he doesn't have $125,000.
As you answer the question, you were in your 8th minute. Actually in the 9th minute, but don't worry about that part.
Your Honor, that's unclear. And again, to us, this is categorically a type of non-monetary condition similar to other non-monetary conditions like
Well, it would seem
injunctive
to me
relief
if
that
someone is advancing an argument of impossibility, that it would be their burden of proof to show impossibility.
Your Honor, I don't think this is where the courts, in assessing the validity of this condition, whether it creates an impossibility, whether it's akin to injunctive relief, whether it requires reliance on third parties, as I said, it's not worth the price of the candle. They should be categorically disallowed. Here, everything that's in this record that speaks to it, and we didn't have an evidentiary hearing below, but we had assumptions. Everything in this record indicates the common sense proposition, and I think we would all be under the same inability, everybody on this call, of not having the ability to write a check for $125,000 in 20 days without the assistance of some third party. And so again, let me stop there and reserve whatever balance of time I have. Thank you.
Thank you, counsel. Mr. Lugo?
Thanks, the court. My name is Ezekiel Lugo, and I represent the appellant, Security National Insurance Company. As I mentioned before, I'd like to reserve 2 minutes for rebuttal. And this morning, we request that the court reverse the final judgment for 3 reasons. First, if the court reverses in case number 2D19-2050.
I'd like you to pause for a minute. Mr. Caldevilla, are you okay? I saw you waving your hand. You need to put on your microphone.
I apologize. Mr. Lugo's speaker is very loud. It's got some kind of weird feedback when he
Okay,
speaks.
he's coming through okay here, so I have no technological skills. Mr. Lugo, do you know of any feedback possibilities over there?
No.
I've turned down my speaker just so maybe, but it sounds like his microphone is maybe at the highest level, but I'll do my best. Sorry to
Okay.
interrupt you, Mr. Lugo.
No, that's okay. Thank you very much. I saw you waving. I didn't know if there was something that I could fix. Mr. Lugo, we'll go back to the beginning. You completed your introduction, and I will now start your clock again.
Thank you, Your Honor. The court should reverse for 3 reasons. First, if the court reverses in case number 2D18-3427, it should reverse in this case as well. Second, the non-joinder statute 627-4136 does not allow joinder of an insurer that does not cover a cause of action for which a verdict was rendered. And third, the 2 cases cited by the trial court did not support joinder in this case, where it was undisputed that Security National did not cover the bodily injury liability claims that resulted in the verdict in this case. Turning briefly to the first issue, if the court reverses and finds that the proposal for settlement was invalid and reverses the award of attorney's fees, then it should reverse the judgment that joined Security National to that fee award for the reason that the proposal for settlement was invalid. And I would like to point out that in that case number, Security National was not a party yet when the court made that entitlement determination, but the Security National is aligned as a party to the appeal as an appellee, although really it is aligned with the appellant's position. Turning to the second issue, the non-joinder statute 627-4136, our argument is that that statute does not allow the joinder of any and all liability insurance carriers. It limits the kind of liability insurance carrier that may be joined to a judgment at the end of the case. And that argument is based on the text of subsection 4 of the non-joinder statute, where the legislature wrote that the liability insurer may be joined unless the insurer denied coverage under the provisions of section 627426, subsection 2, or defended under a reservation of rights pursuant to section 627426, subsection 2. Those two references to that statute, 627426, which is known as the Claims Administration Statute, indicate that the legislature contemplated that it would be an insurer that would be capable to deny or defend subject to the provisions of section 627426.
Were they met? Were they met, the conditions of that statute?
The conditions of the statute didn't apply, Your Honor, because that statute, the prefatory language to 627426 subsection 2 applies when an insurer may, quote, deny coverage based on a particular coverage defense. Those last two words, coverage defense, is a term of art that had been interpreted by the Florida Supreme Court in the AIU Insurance Company versus Block Marina case to mean defense to coverage that otherwise exists. There has to be coverage in the first place. These are situations where the insurer will forfeit coverage. Things like an assertion that the insured gave late notice, or that the insurer made a material misrepresentation.
So by the terms of the policy, it would be covered, but for some deficiency on the part of the claim being made.
On the part of the policyholder, Your Honor, that would result in a forfeiture. If the insurance company is asserting a forfeiture type of coverage defense, then section 627426 applies, and the insurance company has to comply with the technical requirements of that statute. The Florida Supreme Court explained that coverage defense does not apply when the insurance company is asserting a complete lack of coverage. And these are things like it doesn't come within the insuring agreement, or it's subject to a coverage exclusion, or there's just no coverage at all under the policy or as a matter of Florida law. And this has been applied in situations where the coverage has lapsed, or the insuring agreement hasn't been triggered, as I mentioned before. And this,
Mr. Lugo, could you help me out here, please? Does Macedo operate in this domain where you're dealing with the statute so as to suggest that this isn't a derivative coverage, but rather the payment is a standalone coverage?
No, Your Honor. In both Macedo and Gray, the two cases that the trial court cited, those were cases where there was no dispute, there was no fight, that the insurance policy at issue covered the claim for which a verdict was rendered in those cases. So there was no discussion of whether the joinder statute itself applied or did not apply. The court went ahead and interpreted the policy provisions in that case.
So the argument here is because there was no bodily injury coverage, there's nothing for the attorney fee cost of supplemental coverage to attach to and to provide another layer of coverage, because there's nothing involved in this. And it's not a standalone coverage is what you're saying.
That's part of the argument, but the main
Okay, thank you.
there's no compliance with the non-joinder statute to allow this issue to be litigated and decided at this point. The claimant is required to file a separate action either for declaratory judgment, coverage by estoppel, one of the theories they raised at one of the hearings, or a bad faith action, a separate action to decide those issues. Joinder, the insurance company can be brought in at the end of the case under 6274136.
Mr. Lugo, and you mentioned, bringing a separate deck action. Equally here, though, couldn't Security National have brought a separate deck action?
Yes, Your Honor, but I don't, the statute does not require that as a condition precedent.
I understand you just mentioned it that the claimant could, but equally the insurance company could as well. The one question that I had with respect to, because this kind of boils down to, I think where the trial court was honing in on was the fact that Security National did what is called a courtesy defense, not a reservation of rights, but a courtesy defense. And I'm guessing the distinguishment here is because there was no coverage because the bodily injury limit of liability was rejected by the claimant. And so the court focused in on the fact that Security National had provided all along after the property damage had been resolved, a courtesy defense. And is it your point that regardless of any kind of defense that was offered to the claimant, that that it's not inconsistent with the denial of coverage? Meaning that you can't create coverage where coverage, I guess, doesn't exist in the first place. I mean, that's one of the, rules of law that we've all learned over the years. And so, but the fact that Security National continued to provide a defense, I think, was in the way of what the trial court was looking at. Can you kind of resolve that for me?
Your Honor, and my time is concluded. Judge Castaway, if I can briefly answer this.
You're only at 7:50. Go ahead and finish.
Okay, so that issue, whether it was a courtesy defense or a defense or the reservation of rights, that's relevant to whether there was compliance with the claims administration statute. And like I mentioned before, the non-joinder statute, what it requires is that the liability insurer provide coverage for the claim at issue for which a verdict was rendered. It was undisputed here that no such coverage existed. So the non-joinder statute doesn't apply, and Security National shouldn't have been joined to the judgment in this case. The trial judge did place some emphasis on that particular aspect of the letter, but our argument is that it shouldn't have gotten to that point. There is no coverage by estoppel. The AIU versus Buck Marina case I mentioned before made it clear that non-compliance with 627-426 subsection 2 does not create coverage that doesn't exist. If there's no coverage in the first place, the injured claimant cannot rely on the claims administration statute to establish that there was coverage.
Thank you, counsel. All right, let me stop the clock here. Clear that. I have all my technical stuff cleared. Mr. Caldevilla, you may proceed.
Good morning, Your Honors. May it please the court. I am David Caldevilla. I'm here today on behalf of the appellees, Maria and Juan Gonzalez. Also with me in my office today is my co-counsel, Mike Rowe. He's hidden by my virtual background, but he's very close by. Because of the limited amount of time available, I'm going to spend most of my time responding to the insurance company's appeal. With respect
Mr. Caldevilla, before you do that, then perhaps this would be an opportune time for me to present my question.
Yes,
And I appreciate everybody talking about a concurrence I wrote. It proves to me that occasionally somebody reads what we write. I look at the offer of judgment here, whether or not it's based on the amount of the offer, or let's say the case would have been evaluated for near what the jury returned. Say, I think it was 700,000+, let's say $500,000. What happens if there's a cash or a check, requirement of payment? It seems if the statute and the implementing rule is to end litigation, what we are doing by the operation of this offer is suggesting what is normally the law for post-final judgment collections can be obviated by a proposal for settlement, plus it gets a sanction if it's not accepted. I'm concerned about that functionality. Is it something I should be concerned about or not? It's something that maybe the legislature should worry about.
That's exactly my answer. Counsel is asking this court to disallow something that the rule specifically says is allowed. And I too was in the Desidue case, Judge, as you recall.
Yes, I remember.
And that was a case where there was an impossible condition. The insurance company was asking my client to sign an affidavit that was a lie.
Fraudulently.
It was a lie. And,
Yes.
and they often, defendants often put conditions on offers of judgment that cannot be included in a judgment, such as a confidentiality provision or a release, or in that case, it was a covenant not to sue and an affidavit for whatever, I don't know. But this is often done. And as your concurrence in Desidue recognized, conditions are allowed. And there is no restriction on it, except to the extent that they're asking a legal impossibility. In this case, as Judge Smith has rightly recognized, they're claiming that this proposal for settlement is unenforceable because it was impossible to perform. Well, the burden of demonstrating that the proposal for settlement is invalid is on the party asserting that position. They presented no evidence. And let me make clear, Judge Casanueva, you're under the impression that the property that is in the record here is homestead property.
And that's inappropriate if there's no record evidence. That's an assumption. And I know what happens if you shorten that word down, not trying to do it. It was just to illustrate my question.
Okay, I just want to make sure everybody's clear
Yes.
that the property that's in the record is a non-homestead property. That
I appreciate that correction. You're absolutely right.
So unless there are any other questions about the proposal for settlement, I just rely on the brief because.
Let me ask you about the proposal. As I look under relevant conditions, and I want to make sure I have it, it says the second one is subject to the check being in the possession. And the question I have is, what check, issued by whom? Is it a personal check, a cashier's check, or whatever? Or is that a necessary concern that I should have as I look at it if it wasn't preserved?
It was not preserved. So no, the answer is no, you shouldn't be concerned by that. They claim he didn't have the money.
Okay.
No proof
So
of it.
it wasn't a question of the clarity of the proposal. It was a question of its operational necessity on him to perform.
Right. It's clear that there was a check required to be paid within 20 days. It doesn't matter what kind of check, as long as it's not going to bounce.
Well, let me look at it this way. If he would have accepted the proposal and you had a final judgment and then he offered no check, it would have been a very interesting issue here because you have your final judgment, you have an amount. The rule and statute is to obtain the end of litigation, and you would have obtained the end of litigation, and then you would have moved in the normal course for collection efforts. Unless you would have had to say that this was not a fair measure of the damages, I guess that would have been a way to get around it.
Right. This was a heavily discounted offer. There was a condition. Conditions are allowed. And if, they don't like the fact that conditions are allowed, it's time to go to the Florida Supreme Court and explain that to them to take that out of the rule. But until then, it's not this court's prerogative to just ignore that
I agree.
provision.
I
in the
understand.
rule. Thank you.
It seems like I've been writing on these things since before Sarkis.
I know, I'm right there with you, Judge.
Yes, you've been arguing as well.
This is not my first PFS. So unless your honors have any other questions about the proposal for settlement, I will turn to the insurance company's appeal now concerning the supplemental payments coverage. Your honors, we submit the trial court correctly joined Security National as a party defendant to the fees and cost judgment in the case. Now remember, we did not seek to join Security National to the damages judgment because there is no bodily injury coverage, but there is supplementary payments coverage in that policy. And your honor asked Judge Casanueva whether that's standalone coverage. Well, I leave it to you to look at the policy at page 211 and 212 of the record, the record number 2. When they are providing bodily injury coverage and property damage coverage, that liability coverage portion of the agreement says we will pay damages for bodily injury and property damage. When you go down to the supplementary payments provision, it says, in addition to our limit of liability, we will pay other reasonable expenses incurred at our request. That's coverage. Supplementary payment coverage.
Mr. Caldavia, limit of liability. The limit of liability on property damage was $10,000.
That's correct.
Okay. And so we don't have that same provision when we look at the deck page and look at bodily injury.
Well, you have to look.
It doesn't have any limitation on liability because it was rejected by the claimant here, right?
Well,
and so
it was rejected.
The bodily injury coverage wasn't rejected.
Yes, it was rejected. We acknowledge that.
Okay.
But there is supplementary payments coverage. And you should also read, Judge, the portion of the insurance agreement that says we will settle or defend at our expense as we consider appropriate any claim for suit asking for these damages, back referring to property damage and bodily injury. Attorneys selected by us will provide a defense to such suit after it's been tendered to us. So it doesn't, in this case, Security National provided what they want to call a courtesy defense. They sent a letter to them, to the Reyes, saying, we're giving you a courtesy defense. It didn't say that we're giving you a courtesy defense and you're in control of that defense. You're going to call the shots, Mr. Reyes. And every month.
Let's be clear though. I mean, there were a number of letters that said you do not have bodily injury coverage. Hey, by the way, and if you have assets in addition to the amount that are being offered, then go ahead. You know, you may need to use those assets. I can't.
That's not what it says. The letter says if you want to, let us know. But they're offering, the insurance company offered the Reyeses what they called a courtesy defense for this bodily injury claim, and the insurance company was in control of that defense. Make no mistake about that, Your Honor. They were in control of it. They didn't tell Mr. Reyes, you're calling the shot. These are your free lawyers. We're providing you pro bono counsel. We're not going to send you, or we are going to send you bills. You're going to pay when we go to trial.
Yes.
We have to hire an expert. We're going to pay for. You're going to pay for that expert. Yes, sir, Judge.
The being in control of the defense and courtesy defense. What does that matter when subsection 1 of the statute seems to rely solely on whether under the policy,
Right.
it's covered, insured under the terms of the policy, not whether, albeit there was ambiguity in the policy, they decided to provide a courtesy defense to avoid a bad faith claim, et cetera, et cetera. Okay. The statute says under the terms of the policy. Right.
So there's two answers to that. First of all, subsection 1 does not apply in this case at all. Subsection 1 of section 627-4136 is very clear. It's talking about, it says it's a condition precedent to the accrual or maintenance of a cause of action against alert.
Excuse me.
So that's when, and this is the older part of the statute, subsection 4 was adopted in 1990. The Hazen versus Allstate case explains the different spheres of operation of those two subsections. And that's a decision out of this court. But subsection 1 applies when I'm a plaintiff and I want to sue the defendant and his insurance company. Well, in Florida, you're not allowed to do that because they don't want to prejudice the jury, to let the jury know that the defendant is insured. So that statute, which was in place for a long time, said, look, you got to wait till you get a judgment against that insured defendant, and then you have to sue the insurance company separately to get the insurance company to pay that.
Right.
Now, in 1990, that process was emasculated, basically, replaced by subsection 4 that says, look, that is and if you read the Hazen versus Allstate case, which is cited in Security National's answer brief, that's a second DCA decision, Judge Wallace goes through and explains the history and how these things work. Well, in 1990, they adopted subsection 4, and they said, this is a very cumbersome process that we have in subsection 1. We can bypass that by giving the insurance companies an opportunity when they know that there's a coverage problem to put their insured on notice by sending them a certified letter saying we're denying that kind of coverage and we're going to reserve our right to defend. So in this case, a proposal for settlement went out. Well, let's go back to the courtesy defense letter. If you look at the courtesy defense letter, it doesn't say we're denying supplemental coverage, payments coverage, and that is coverage under this policy. Make no mistake, that is coverage, just like rental car coverage when you get in an accident. That is coverage. When they said we're providing you a courtesy defense, it did not say, and by the way, the supplemental payments coverage is not going to apply from this point on. We hire an expert, you're going to pay that. We take an appeal, you're going to pay the filing fee. We advise you not to accept the proposal for settlement because we think it's ineffective or void. You're paying for that anyway. There's nothing like that in that letter. Then, with respect to I just lost my train of thought. In any event, subsection 4, when the proposal for settlement came, you would think at that point, the insurance company, there's case law saying insurance companies under your supplemental payments provisions, you're going to have to pay costs, you're going to have to pay attorney's fees. They should have sent a letter to Mr. Reyes at that point, a registered letter, a certified letter, according to the statute, saying, look, you got this proposal for settlement. If you accept it, fine, we're not paying for it. And if you reject it, we are not paying for any attorney's fees or costs under the supplementary payment provisions of your insurance policy. They would have had to exercise the procedure in subsection 4 of the non-joinder statute to obviate that procedure that was adopted in 1990. They did not do that, or if they did, they haven't put it in evidence, which is their burden. It's their burden to show they sent a registered certified letter to their insured saying, we're not covering you for this if you reject this offer of judgment. Know it now. They didn't do that. So they did not comply with the statute, Judge Atkinson. When you asked were the terms met? No, they were not met. There's coverage here. They provided this courtesy defense, and that courtesy defense, Mr. Reyes was not in control of it. They were in control. They decided to take the
Mr.
last.
Caldavia, did the court find there was coverage?
There's supplemental payment coverage.
Well, I okay, but did the court make any finding on coverage? I mean,
Not an express finding, but that'd be the only way that the court could join them to this. She cited to the New Hampshire Insurance versus Gray, Macedo, Geico versus Macedo case, where both of those decisions say that the insurance company has to cover the litigation expenses. So I don't know how there's any other way.
But you would agree in that case there was coverage.
Yes, and there's coverage in this case. There's coverage for supplementary payments for litigation expenses that the insurance company causes their insured to incur. If you think about it, in this case, if the Reyes did not have this courtesy defense, they would have been better off. They would have been better off without this courtesy defense, because at the end of the day, because of the insurance company's decisions in this case, because of the vigorous defense that they opposed on my client, who was a victim of a head-on collision, high-speed head-on collision, clear liability, huge damages, they decided to vigorously defend that, run up the attorney's fees in this case. They rejected a $10,000 policy limit settlement offer to resolve all claims at the beginning of the case. And the reason for this courtesy defense was not for the benefit of Mr. Reyes.
And you're alluding to a bad faith claim. And so, I mean, wouldn't this be best litigated in a deck action? And then if a bad faith claim was brought, then that's a matter for the claimant to bring against the insurance company here.
That's certainly an option, but you know, we're supposed to follow the statutes. You know, there's a lot of talk about in the law now how the courts, you know, we need to follow the statutes, and there shouldn't be.
Speaking of the statutes, what in subsection 4 delineates which insurers should and shouldn't be joined?
What it says is, at the time, subsection 4 says, at the time of a judgment is entered or a settlement is reached during the pendency of the litigation, a liability insurer may be joined as a party defendant for the purposes of entering final judgment.
Any liability insurer?
Yes. What is this, Your Honor?
Well, you're arguing that, you know, you're conceding that only liability insurers whose policy covered the claim should be joined. Well, where do you get that from in subsection 4? You're conceding.
I agree. Right? They are a liability insurer for the supplementary payment coverage that they.
No. Where the standard that you've conceded, which is that for joinder, only insurers whose policy covers the injury can be joined. Where do you get that in subsection 4?
I just read it. That's exactly what it says.
Where?
At the time a judgment or a settlement is reached during the pendency of litigation, a liability insurer may be joined as a party defendant for the purposes of entering a final judgment or enforcing the settlement by the motion of any party, unless the insurer denied coverage under the provisions of 627, 426-2, or defended under a reservation of rights pursuant to that same statute. They didn't do that. They didn't do that. They defended.
Don't you first need to? But where do you get the where do we get the requirement that their policy cover the injury to begin with? Where in the statute?
Your Honor, it says, I'm not following you, quite frankly, it says.
Can we get it from subsection
Liability
1?
insurer. Who's the liability insurer? The only liability insurer is Security National. We served a motion on the liability insurer.
Don't you get that from subsection 1? The requirement that the policy cover the injury? You're saying subsection 1 doesn't apply.
Let's say I assume you're correct. This policy, this liability insurer covered these litigation expenses. They promised to pay the litigation expenses that were incurred by Mr. Reyes at their request. And the Macedo case, which reversed this court's decision in Steele versus Lindsay, said when it's made at their request, we really mean who's in control of the litigation, who's in control of the defense. Is it the insured calling the shots, or is it the insurance company calling the shots?
Mr. Cadavia, so what you're saying is by creating a courtesy defense that was outside the policy, you would agree with me on that, right?
I don't know why any insurance company would provide free pro bono legal expenses. They had a duty to do that.
Well, let's look at the policy. You probably know it better than I. And is there any provision for a courtesy defense?
I didn't read one anywhere.
I didn't read it either. And so by providing this courtesy defense, I think is what you're saying, that because that is outside the policy, that somehow triggered the supplemental payments.
Well, yes, but let me answer it this way.
And so if we go back to that, I have to look at the policy. You're saying then that an insurance company, by providing a courtesy defense, by doing that very defense, that they are then changing the terms of the policy to subject them to further liability for these expenses.
It's not changing the terms of the policy. The policy.
How is it not?
Promises.
You're creating a coverage that wouldn't have existed otherwise, because you said it yourself that, hey, they would have been better off if they didn't provide this courtesy defense, then they wouldn't have subjected themselves to liability.
Okay.
And so the reverse then, I have to test it, is that the courtesy defense wasn't even a part of the policy.
All right. Well, let's test it this way. Let me answer the question. The policy provides supplementary payments coverage if expenses are incurred at their request. Let's say during this courtesy defense, let's say that the defense counsel got tagged with a discovery violation or a 57105 motion because they did something frivolous, and there was a sanctions order entered against them. Would Mr. Reyes have to pay that, or would the insurance company have to pay it? I'd say the insurance company has to pay it under the supplementary coverage. And let me say one last thing. I don't know where I am on my time, but
You're at 20, but since I gave everybody else an extra minute, you get the extra 2 as well.
thank you so much, Judge, because in this case, let's be clear. Both appellants acknowledge that the cost, the $30,000 in costs awarded by this judgment, have to be affirmed. They have acknowledged. If you look at page 30 of Security National's initial brief, they say, I'm quoting, to be clear, the judgment in September and the amended judgment in April include an award of cost against both Mr. and Mrs. Reyes. The costs awarded presumably are not dependent on the offer of judgment. Thus, a portion of the judgment may remain after reversal in the second appeal. I responded to that in point 5 of my answer brief, and I said, you're acknowledging that you owe the costs. And then on page 10 of Security National's reply brief, they say Ms. Gonzalez claims the award of costs will not be affected by the outcome of case number 1. Security National noted as much at page 30 of their initial brief. Now, where is Security National's liability for costs coming from? It's coming from the supplementary payment provision of their insurance policy. And under Macedo, that includes attorney's fees. They have conceded that they are tagged with that $30,000. You have to affirm that. And if you affirm that, attorney's fees are covered too. And for these reasons and the reasons in our brief, I request that you affirm this judgment. Thank you very much.
Thank you, counsel. Right on time. Okay. Let us return to the appellant's counsel for their 2-minute presentation per counsel. Mr. Baruch, I believe you get to go first, sir.
Thank you, Your Honor. A quick point and then a request. First of all, the implementing rule, the rule that implements the statute, does allow, without explanation or elaboration, non-monetary conditions. But that can't be construed to allow for conditions that overthrow the statute's basis purpose of forcing the parties at an early juncture to assess the merits of the case and end litigation. This non-monetary condition, this time-limited payment demand, is unique in that it throws an obstacle directly in the way of acceptance in a way that a confidentiality provision or a hold harmless provision does not. And it is, counsel said that the rule allows for non-monetary conditions without limitation, but it is akin to other non-monetary conditions or attributes of offers that have been disallowed by the courts. And this is basically comes down to an unpled request for injunctive relief. It is equivalent to that, the requirement to pay $125,000 within 20 days. The request I would make is this, given the novelty of this issue, if these types of conditions are not going to be categorically disallowed as violative of the statute, what we would ask is for the court to return this to the trial court to undertake that evidentiary determination. Below, the argument that convinced the trial court, what was argued, was that Mr. Reyes's inability to pay was irrelevant to the enforceability of the offer. If it is relevant, we'd ask the court to return this to the trial court so that we can file an affidavit attesting to what everybody knew and what everybody assumed below, that Mr. Reyes is not that rare individual who has $125,000 sitting in a savings account or a checking account that would have allowed him to strike a check to plaintiff's counsel within 20 days. And it's my client was sanctioned below for not accepting an offer that he couldn't possibly accept. And counsel is asking this court to impose that same sanction on Mr. Reyes for not accepting a condition or not accepting an offer that he couldn't accept, and frankly that 99% of us couldn't accept. And so we'd ask.
I think your time has expired.
Thank you.
Mr. Lugo.
Mr. Court, I would like to address 2 points. First, there was no concession in the reply brief that the cost judgment needs to be affirmed. The argument there says that the cost, the portion of the judgment about cost would not be affected by the outcome of case number 2D19-2050, the entitlement related to a proposal for settlement. There is no concession there that joinder was proper as to cost. Joinder was not proper because, as Judge Atkinson pointed out, subsection 1 applies here, and it's a condition precedent, and Hazen said that, and the 4th DCA said that in the Roberts case. There has to be a verdict, quote, for a cause of action which is covered by such policy. If there is no cause of action covered by the policy, there is no joinder. There has to be a separate action. There cannot be coverage by estoppel, coverage outside the policy. Judge Smith, even if this courtesy defense, even if they could prove that the courtesy defense created some extra contractual coverage here, that cannot be asserted in a joinder claim because subsection 1 does not allow it. There has to be a cause of action, a verdict or a cause of action for which coverage exists under the policy, and that is not an issue here. If that is met, then the court looks at the second part, which is now that there's a liability insurer that provides coverage, was there some kind of forfeiture provision that was asserted for which there was a denial of coverage or a reservation of rights under the claims administration statute? If there is a forfeiture argument and there has been compliance with the technical terms of that statute, then joinder is not allowed. But here we don't get past the first part, subsection 1, because there is no verdict for a cause of action covered by the policy, as admitted by opposing counsel during his presentation. There was no bodily injury coverage in this case. There should have been no joinder. This court should reverse the judgment, joinder security national.
Your Honor, may I be heard on just one point? Mr. Baruch.
Let me anticipate, Mr. Caldevillo, in light of your supplement of authority, that this was raised in a reply brief and was not in the initial brief. Do I anticipate it well?
Very good, Judge. I'm glad you read that. I appreciate it. Thank you.
Thank you. I thank you all for your presentation today. Being technologically challenged, I understand you have a procedure for leaving and we bring in the next people. Thank you so much. Please stay well.